I'm Ed Livingstone. I'm an associate at Fox Williams, and I'm going to talk about changing terms and conditions of employment contracts. So this is a complex area of law with a number of pitfalls, and the costs of getting it wrong can be high. So I want to set out a roadmap which can help HR to come up with the most easy solution for changing employment terms and conditions via the path of least resistance, because unfortunately it's not as simple as having a wide power of flexibility in the contract to change working patterns at an employer's will. The courts are willing to find restrictions implied on those powers and also narrowly interpret them so that they might not be in scope. So I want to talk about a sort of 5-step roadmap by which employers can identify and implement the most straightforward way in which they can change employment contracts. So firstly, you need to make sure you've identified the relevant change and to verify whether or not it is contractual at all. Something within the current job description wouldn't be a contractual change, and changes can be made simply by notifying the employee. But if it is a change to contract, you then want to look at specific flexibility clause, such as something to do with location. So you'd have a term in the contract which sets out a standard working location, but also a flexibility for the employer to designate other places for the employee to work. Now this is, as I mentioned earlier, subject to implied restrictions and a narrow interpretation. If you can't get home on a specific flexibility change, you then look at a general right to vary the contract. So it might be written out that the employer may vary the terms of the contract as it may notify to the employer from time to time. But again, this is subject to implied restrictions and probably can't be used for anything more than non-fundamental or minor policy changes. So if there's no ability within the terms of the contract itself to vary the terms and conditions of employment, you're then looking at either getting the consent of the employee, agreement to mutually vary the contract. This is straightforward in non-controversial changes, but of course more political and fraught with difficulties if we're talking about a potentially detrimental change. It is possible to threaten dismissal as a potential means of getting agreement. However, you'd want to look out for the employer's duties of trust and confidence towards the employee, which might well be breached by doing so. As an alternative to that, as a sort of last step on the roadmap, there's dismissal and re-engagement, by which an employee is expressly dismissed by giving notice and then re-engaged with the varied terms of the contract. This is not a breach of the contract, but it might be an unfair dismissal if the terms are so fundamentally different. Or, as a final alternative, you can impose the changes in breach of contract simply by imposing them on an employee, although as a practical matter this might be easier with something like pay, which is in the employer's control, as opposed to something like working hours, in that an employee could continue to show up at the old times specified in the old terms of contract. So I've talked about a number of ways in which employment contracts can be validly varied. Following that process and finding the most straightforward way of doing so will yield lessons such as the terms it's important to have in employment contracts going forward, as well as strategic considerations. It might be that you have to tie in the seeking of mutual consent of employees with, if it's on a sufficiently large scale, collective consultations for redundancy. So there are a lot of strategic pitfalls, but going through from simplest to most complicated, the most straightforward method can be identified.